Okay, so now we're looking at Lively's opposition to Wayfarer's motion to exclude the testimony of Ashlee Humphreys. Dr. Humphreys, a professor of integrated marketing communications at Medhill School of Journalism and professor of marketing at the Kellogg School of Management, Northwestern University, will assist the jury in quantifying the reach of harmful language about Ms. Lively associated with defendant's retaliatory campaign and the reputational damages attributable to defendant's retaliatory statements. She applies her widely recognized expertise in marketing, social media, and consumer research to analyze and explain 1. The value of person brand, including for public figures like Ms. Lively. 2. How broadly key terms from the alleged retaliation campaign spread across various media channels and the harm to Ms. Lively's reputation and personal brand. 3. How broadly 5 statements made by defendant's agent about Ms. Lively spread across various media channels. 4. The receptivity of the audience to these retaliatory statements, the persistence of the audience's negative opinions, and the corresponding damage to Ms. Lively's reputation. And 5. The estimated costs of a mixed media marketing campaign to repair the damage to Ms. Lively's reputation caused by the retaliatory statements calibrated to the media spread and audience. In their motion, the defendants do not challenge Dr. Humphreys' qualifications to offer her opinions, nor do they meaningfully challenge the admissibility of Dr. Humphreys' impressions model for retaliatory phrases or her impact assessment. Instead, they levy the erroneous claim that the retaliatory statement testimony is now irrelevant because the defamation cause of action has been dismissed, and the counterfactual claim that Dr. Humphreys' opinion about the harm caused by the retaliation campaign is based entirely on Dr. Maislin's analysis, together with a set of scattershot arguments related to other aspects of Dr. Humphreys' opinions. Because defendants failed to raise any credible challenge to Dr. Humphreys' opinions, the court should deny their motion in full. Okay, background. Dr. Humphreys' expertise in social media, marketing, and reputational repair. Dr. Ashlee Humphreys has been on the faculty at Northwestern for 17 years, regularly teaching classes on social media, consumer and marketing research, crisis communication, and reputation repair. She serves in several high-level editorial positions for top journals in the field and has received various rewards and recognitions, including as a Marketing Science Institute Scholar, one of a select group of 35 marketing scholars recognized as amongst the most prominent marketing scholars in the world. Dr. Humphreys regularly publishes peer-reviewed research and literature about digital media, social media, and marketing strategy. Among these, she is the author of Social Media, Enduring Principles, a review and synthesis of the empirical social science research on social media. Her research on how markets are created through shifts in social structure was selected as a lead article in the Journal of Marketing, the highest impact peer-reviewed journal in the field. Dr. Humphreys has also served as a qualified expert on numerous occasions, deploying similar analysis in cases involving reputational damage, including in this district. Okay. She was in the... Okay, so she was in the Trump case and the Giuliani case. Dr. Humphreys' analysis in the instant case. Ms. Lively retained Dr. Humphreys to analyze the impact, if any, to Ms. Lively's reputation from the retaliation campaign orchestrated by defendants to manipulate online discussion of Ms. Lively beginning in August 2024, as well as the reputational impact of retaliatory statements made by defendant's agent in December 2024 and January 2025. Dr. Humphreys 1. Calculated the number of impressions of the retaliatory phrases and assessed the resulting harm. And 2. Calculated the number of impressions of the retaliatory statements, as well as conducted an impact assessment and a related damages model, estimating the costs to repair Miss Lively's reputation based on the impact of those impressions. For her impressions models, Dr. Humphreys gathered and summed the impressions from each source that contained the content of interest, including A. Social media platforms such as TikTok, YouTube, Instagram, Facebook, and X. B. Online news websites and articles using the third-party analytics tool SEMrush. And C. Television. Her approach incorporated platform-reported view counts, i.e. impressions counts, where available, and she documented each step of her analytical pipeline. Based on this data, Dr. Humphreys calculated over 176 million impressions of posts associating Ms. Lively with the retaliatory phrases and approximately 116 million impressions of the retaliatory statements, each of which she describes as conservative estimates. For her impact assessment, Dr. Humphreys evaluated several factors to determine whether the retaliatory statements harmed Ms. Lively's reputation, including the credibility of the sources, the prominence of the publications, and the prevalence of the statements in online discussions regarding Ms. Lively. Dr. Humphreys concluded that the retaliatory statements damaged Ms. Lively's reputation, noting that untold numbers of online comments repeat the claims, which indicates that many consumers were receptive to the retaliatory statements and that those statements drove an attitudinal change towards Ms. Lively. For her damages model, Dr. Humphreys estimated the costs of a corrective mixed media marketing campaign calibrated to repair the reputational harm caused by the retaliatory statements. Drawing on peer-reviewed research establishing that changing an existing attitude requires approximately 3 to 5 exposures, Dr. Humphreys calculated the cost of generating the necessary corrective impressions across each media channel in proportion to the original sources of dissemination, using industry standard cost per mille rates. She further adjusted for audience receptivity using your YouGov consumer polling data, applying a 55.2% receptivity rate, reflecting the percentage of US adults who did not view Ms. Lively favorably. Based on this methodology, Dr. Humphreys estimated that a corrective campaign for the retaliatory statements would conservatively cost between 14 million, really? $14,625,160 and $24,375,267. All that just was, mean girl and tone deaf, really? Argument. Dr. Humphreys' expert testimony satisfies each requirement of Rule 702. Her opinions are the product of reliable principles and methods governing the fields of marketing, social media analysis, and consumer research, and she has reliably applied those methods to the facts of this case. Her testimony will help the trier of fact determine key factual questions at issue, namely the reach and impact of the retaliatory narratives on Ms. Lively's reputation and the cost of repairing that harm. Dr. Humphreys' testimony about the retaliatory statements is relevant. Contrary to defendant's claim, the court's dismissal of Ms. Lively's defamation cause of action does not make Dr. Humphreys' testimony about the retaliatory statements irrelevant. This ignores the pivotal role that the retaliatory statements play in Ms. Lively's surviving retaliation, aiding and abetting and contract claims. Because the retaliatory statements are a core part of the retaliation campaign, Dr. Humphreys' testimony about the reach and impact of the retaliatory statements and the damages Ms. Lively suffered from them remains central to the questions the jury must decide. Like their motion in limine to exclude Dr. Humphreys' testimony about the retaliatory statements, defendant's Daubert challenge rests on the false premise that, because the court dismissed the defamation claim on privileged grounds, evidence of the damages stemming from the retaliatory statements is no longer relevant. Once again, that is not the law. The dismissal of a cause of action on privilege grounds does not render evidence relating to the underlying conduct irrelevant, where, as here, it is independently probative of different surviving claims and independently supports recoverable damages flowing from retaliatory acts. See, I don't like this, because they, their cause of action. So if the defamation claim had remained, then Lively would have been entitled to damages for that. It was dismissed, but that she's still seeking to introduce the same evidence, under the guise of the retaliatory statements and effectively obtain damages that she now can't claim due to the defamation cause of action being dismissed. And she's kind of trying to back end and litigate those same statements that have already been dismissed. And I don't like this at all. I don't like this at all. She should not be allowed to do it. As Ms. Lively has consistently alleged, defendants retained Friedman specifically because of his reputation for being willing to bury his client's opponents. But how are you going to prove that? He's an attorney. They retained an attorney. Because she filed the CRD. I mean, Friedman, let's not forget, whilst there may have been talks with whether or not to retain him back in around July, August time, he wasn't actually retained until December after she filed the CRD. Speculating that they may retain an attorney because they are considering, taking legal action, which they did not go on to take until much later after the CRD and the New York Times article, is not evidence of anything whatsoever. Then, after Miss Lively filed her CRD complaint, an act unquestionably protected by the FIHA. Oh, God. Right, do you know, she's not, until now, she's never argued that it was a protected act at all. She's not made that argument until Judge Lyman practically made it for her. Then, after Miss Lively filed her CRD complaint, an act unquestionably protected by the FIHA, Friedman made good on his promise to sue anyone associated with Miss Lively's CRD complaint into oblivion by filing defendant's retaliatory lawsuit, then doubling down on the dissemination of this retaliatory content in his statements to the media on behalf of defendants. As such, the retaliatory statements and Dr. Humphreys' testimony about the retaliatory statements remains squarely relevant to the surviving claims. Yeah, but, this is about Lively's reputation and whether there was any retaliation on Wayfarer's part that caused it. And, to say, well, Friedman threatened to sue anyone that was associated with me into oblivion, that's their reputation. That's a whole different, separate issue, which no one has sued for. And they can't because, they weren't engaged in protected activity. Because Dr. Humphreys' testimony about the spread and harm of the retaliatory statements remains squarely relevant, defendants' cases on this point, which involve either a full dismissal or a dismissal of all claims relevant to an expert's opinion, are inapposite. Dr. Humphreys' testimony is reliable and reflects reliable application of principles and methods to the facts of the case. Defendants' remaining arguments fare no better. Dr. Humphreys' testimony relies on well-established principles and methods in the fields of marketing, consumer research, and strategic communications. Her impressions model employs a systematic, quantitative methodology for calculating the number of times content is viewed across media platforms, an approach that is standard practice in the digital marketing and advertising industry. Her impact assessment applies principles drawn from peer-reviewed research on source credibility, audience receptivity, and attitude change to evaluate the reputational harm caused by the retaliatory statements. And her damages model draws on accepted marketing practices for designing corrective campaigns, including industry standard CPM rates and peer-reviewed research on the frequency of impressions required to achieve attitude change. Each component of Dr. Humphreys' analysis is grounded in the same principles and methods that she has applied in her academic research, in her professional work, and in prior federal litigation where her testimony has been admitted. Defendants' superficial attempts to exclude her testimony should be rejected. Dr. Humphreys' opinions are independent of Dr. Maislin's analysis. Defendants make the vague, conclusory claim that the first part of Humphreys' analysis regarding damage allegedly suffered by Lively due to defendants' purported retaliation campaign should be excluded because it is based entirely on Dr. Maislin's analysis, which defendants independently seek to exclude. Dr. Humphreys does not rely on Dr. Maislin's analysis to calculate the number of impressions of the retaliatory phrases and assess harm, and her testimony does not rise or fall with Dr. Maislin's. Instead, as Dr. Humphreys explains, she makes the assumption that a retaliation campaign did occur, acknowledging this in this context that Dr. Maislin found evidence that a retaliation campaign had in fact occurred in August 2024, and then proceeds to calculate the number of impressions of the retaliatory phrases and assess whether and to what extent Miss Lively's reputation was harmed. In particular, after acknowledging Dr. Maislin's findings, Dr. Humphreys conducts her own collections and calculations of impressions from social media, online, and traditional media containing the retaliatory phrases, and undertakes her own assessment of the harmful impact of the retaliation campaign. Nothing about Dr. Humphreys' data, her analysis, or her conclusion that there were over 176 million impressions of posts associating Ms. Lively with the retaliatory phrases and subsequent assessment of harm is contingent on Dr. Maislin's opinions. Any challenge to her testimony based on the assumption that a retaliation campaign did occur thus goes to weight, not admissibility. I really do find this aspect right to say Friedman went and gave an interview to Megyn Kelly where he talked about suing people for stealing the film, for defamation, for calling Justin Baldoni a predator, and all the other defenses, etc. And, kind of making the world, look at all the bullshit that Lively actually pulled that I'm sure she was hoping would be kind of kept away, telling people for the first time that actually Baldoni, Heath, Sarowitz, their wives, their families, their friends, and even a terminally ill guest of Justin Baldoni's were all put in the basement at the premiere. Right? And that caused another wave, an even bigger wave if you look at the graph that we looked at in I think it was I think it was Dina Maislin's video. It was either Dina Maislin or Aaron Coletta where I did their video. But when you look at the graph, right? Okay, we'll just go to it now, shall we, in real time? Because this shit is annoying. Okay, so I magically just, teleported us to the page. But I actually talked about this when I did the video on Dina Maislin. And if you look, right, so you've got this one little spike all the way over here, which is at the end of May 2024. Then you've got a big gap where nothing really happened. Then you got the big spike again around the time of the premiere, right? So I think I kind of said, for me, it looked like it was around the 8th, 7th or 8th of August, at this first little bump here, before you start getting in, it gets bigger at the start, at the end of August. Then it drops, starts to tail off again and go back down. And it was kind of over then, it was going down, down, down. And then all of a sudden you had this massive spike here. This really tall one. I can't show you where I'm pointing to because it doesn't allow me. Yeah, I can't highlight anything. But the first of these really tall columns is the 5th of January. Okay. And yeah, that coincides with Friedman's interview. Do you know what else it coincides with? Everyone filing lawsuits. At this point, right, you'd had the New York Times. You had Wayfarer suing the New York Times in California. You had Lively filing in New York against all the Wayfarer defendants. And yes, Friedman did go on to the Megyn Kelly show. But you know where I think the interest really peaked it? If Friedman's statements had any impact, it's because the world was watching. Because, she filed that bombshell New York Times article and had everyone's attention. Like, everyone's like, what the fuck? What is going on? And at this time then, by this point, we'd had Wayfarers counter arguments with all their evidence. And the world went, oh, that makes more sense. Oh my God, she lied. And they put in all this evidence proving that she lied. And the world got really pissed off and angry with her. And, that just continued. It continued because the next big spike is the 2nd of February. Well, Wayfarer filed their first amended, no, sorry, it's the 9th of February. Wayfarer filed their first amended complaint, where we learned about things like the metadata of the New York Times article, and realized that there'd been more of a collusion than people anticipated. And I think what my thought process is on this, right? And again, it's just my opinion. I don't know, right? But it really looks to me, if trying to be a reasonably objective person about this, right? In much the same way that, she had people's interest because of the release of the film and her marketing, like her how she handled direct questions about domestic violence survivors, and the kind of really gross way that she answered them, almost, like she had some kind of superiority complex, like, oh well, I'm better than them. They don't need to speak to me. I don't know what domestic violence is like. So, and she was basically treating people, and the thought that they might approach her like, she was trying to avoid some sexually transmitted disease. And I really think, that's what people just were really pissed off. I'm like, who the fuck is this bitch, And I don't mean that in a horrible way, but like, I think that's how people were like, what the fuck? What is she doing? Who is she? And then they've gone and Googled her and then gone, "Oh, right, yeah, everything makes sense. Wow, she's offensive to, you know, people of color. She's offensive to transgenders." Yeah, we've got the full bingo card here of, the bigotry. And I think then obviously people's attention was grabbed again by the New York Times. Oh, that's exactly what she designed to do. Okay, so let's not even kid ourselves. She filed all of that and worked on that article for months with the New York Times for it to have the impact, right? She says as much in her text messages with Taylor Swift, on the, literally 15 days before the CRD dropped. They were talking about, it's going to be good, how impactful it's going to be, it's how explosive it's going to be. So she knew damn well that that was going to get public attention. What she wanted was the public sympathy, right? Which she had. She had. And yes, Friedman, they filed against the New York Times. Yeah, the New York Times in California. Yes, Friedman did go on the Megyn Kelly show and give an interview, which he's perfectly allowed to do. That's why the defamation claim got thrown out. But all he said was that, no, this didn't happen. And no, if your wife was sexually assaulted, why would you make a joke of it in Deadpool and Wolverine? Why would you create a character and make fun of it? And, we're going to sue Ryan Reynolds. We're going to sue Leslie Stone. We're going to sue Stephanie Jones. And, he then talked about all the counter accusations, like Justin Baldoni being called a predator, his film being stolen. She wrested control of the film. And, the fact that they all got dumped in the basement while she, lived up her moment on the red carpet surrounded by her A-list, cohorts. And we were hearing things for the first time which were truly shocking. Truly shocking. But we'd also had, the Wayfarer's complaint, which they filed largely in response to the fact that Lively filed a complaint, because don't forget, initially only sued the New York Times, even though when we're going through Lively's opposition to Wayfarer's Daubert motion to exclude Jennifer Frey, the Darbo expert, Lively tried to claim, oh, well, they sued me in 3 different jurisdictions. They absolutely did not. They did not. Because one of those jurisdictions is California, and that was the New York Times, not her. And I likened it, right? And I keep finding so many correlations with the Depp Heard case, and it really pisses me off. But again, Lively saying, oh, they sued me, in 3 jurisdictions, when she did not get sued in a 3rd jurisdiction at all. The UK trial, when she won. So she won shit. And, UK defamation law is, something I'm very familiar with. And so the New York Times, I'm getting annoyed now and I'm getting confused between publications. So The Sun and Dan Wootton, they were obviously sued for defamation by Johnny Depp. And there was a specific legal bar that they had to meet. And the first of those defenses is the truth, basically, the defense of substantially true. So if they can prove that the defamatory statement is substantially true, then they will not be found liable for defamation. And then another defense, in the absence of substantial truth, is an honest opinion. So they've got to have genuinely held and based on facts that existed at the time of the publication. They have to be of an honest opinion. I mean, there are other things such as privilege, innocent dissemination, etc. But those 2 main ones, right? So either they prove the substantial truth of the statement, or that they genuinely held an honest opinion that the statements were true. and it was based on facts that existed at the time. So what did the Sun and Dan Wootton do? They rocked up with the wife of Johnny Depp, who was claiming and testified that he had been abusive to her. And there are, a lot of people will say, "Oh, well, it was rigged." Just judge in it, Justice Nichols, all the ties and everything. I absolutely 100% agree. Right, that was a conflict of interest and a massive one. But at the end of the day, it was quite clear that if the Sun put Amber Heard on the stand, and she wasn't on trial, she was just a witness. She went in, all she had to do was say, yeah, he assaulted me, he abused me, and all this stuff. And at the end of the day, then there's a reasonable basis, the substantial truth defense and the honest opinion defense, they're met. And that is why Johnny Depp lost the UK trial. However, when you put Amber Heard herself on the stand and actually tested her evidence, because her evidence is not particularly tested to the same level as it would have been had she been a party, which we saw. We saw that. So when she actually had to, she was a party in Virginia. Her evidence was subjected to the same rigorous scrutiny and testing that would come with being a party in a case, and she had to testify. And we all saw it. It went so badly. And you have a judge who is fair-minded as well, because the judge in Virginia was just absolutely wonderful. Then you get a completely different result and a different outcome. So just to kind of Friedman to me, right? He didn't do anything beyond the pale, right? Is his tone, a bit, and his language sometimes maybe potentially inflammatory? Yeah, I think it can be. I do, but I do actually think, and I've said this all along, I think Friedman's entire purpose was to tilt the public support back for Baldoni by doing nothing else, nothing more than getting out the truth and the evidence. And all the stuff that Blake Lively has filed so many motions to prevent Wayfarer from doing, including shutting down the website, they were prepared to put all the filings and, various evidence and all that on there for the public to see without having to pay any PACER fees. No, didn't want that either. She waddled into court, less than, I think, only a couple of weeks after the website was, launched, and went and got the judge to shut it down. And that's all I think. I think it's just ridiculous, right? That she's trying to say, well, that harmed my reputation, when actually she's the one who drew attention to her reputation by putting a New York Times article out there, which was so explosive that made the world sit up and pay attention and want to follow what happened next. Because clearly what was going to happen next after she levied all her allegations so publicly was you were going to get someone was going to publicly come out and defend all of these people. And that's what happened. And unfortunately, the people who come out to defend themselves had the evidence to back up what they were saying, whereas Lively did not. So I do not think it is fair, in my opinion, that Lively, gets to have someone to testify about the impact of Friedman's statements. And I hope Judge Lyman does not allow that. I feel like he probably will, but he will allow it. But I don't think it's fair. I think it's unduly prejudicial, in my opinion. Okay, hopefully I've taken us back to the right place. But I think, if I remember correctly, we were talking about his 176 million impressions of posts. Any challenge to her testimony based on the assumption that a retaliation campaign did occur thus goes to weight, not admissibility. Yeah, okay, yeah, I think that's right. Dr. Humphreys' approach to alternative explanations does not render her testimony regarding the retaliatory phrases unreliable. Yeah. Yeah, I did. I think I did bring us back to the right place. Awesome. Defendants argue that Dr. Humphreys' analysis of the retaliatory phrases is unreliable because she failed to investigate or consider any alternative explanations for the purported damage to Lively's reputation. This reveals a misunderstanding of Dr. Humphreys' methodology. Dr. Humphreys conducted a mathematical calculation of the number of impressions on posts containing the negative mean girl, bully, or tone deaf phrases. Any alternative explanations for potential reputational harm beyond these terms are irrelevant to her methodology. Dr. Humphreys' methodology is reliable because it accounts for precisely the universe of relevant content. In turn, defendants' complaints go to weight. Lively's talking an awful lot about weight for someone who is triggered by it. Dr. Humphreys' data collection is reliable. Defendants fault Dr. Humphreys for relying on SEMrush, a third-party analytics platform, to measure impressions of the retaliatory statements. They also complain that Dr. Humphreys did not deduplicate the individuals who create those impressions. First, defendants provide no basis for asserting that an SEMrush is a flawed data source. What they mysteriously characterize as common concerns about SEMrush contradicts that SEMrush is a standard tool that is widely used and relied upon in the marketing industry and in academic research. Nor are defendants correct that SEMrush is unreliable because the tool has not been peer-reviewed. To the contrary, courts have concluded that Dr. Humphreys' method is sufficiently peer-reviewed. The fact that Dr. Humphreys has relied on SEMrush in multiple other cases in testimony as a qualified expert undermines defendants' claim. Moreover, even if defendants' criticisms of SEMrush were correct, they address only a marginal portion, 3%, of the data. As defendants concede, Dr. Humphreys' use of SEMrush relates only to online news, not all the other impressions from social media and television, affected merely 3,559,144 of the total 116,959,530 impressions. Thus, the claim that Dr. Humphreys' testimony should be excluded on this basis is unfounded. Second, the reliability of Dr. Humphreys' methodology does not depend on deduplicating users because she does not base her analysis on users. Instead, impressions are the industry standard approach to measurement, and those impressions are never deduplicated. All of the conclusions Dr. Humphreys draws and the damages she calculates account for this known feature of digital media measurement used in the marketing and ad industry as a matter of course. Putting aside that defendants provide no evidence that Dr. Humphreys counted the same impression twice, she did not, Dr. Humphreys' impression counts are conservative and would more than make up for any theoretical overcounting under defendants' theory. The fundamental point is this: defendants are conflating unique viewers with impressions. Their argument suggests that Dr. Humphreys has drawn conclusions based on a calculation of unique viewers and thus has made an error in her calculations. But Dr. Humphreys calculated impressions, not unique viewers, and therefore none of Dr. Humphreys' conclusions rest on the assumption that 100 million plus individuals were exposed to this information. Defendants might object to Dr. Humphreys' decision to use impressions as the operative metric, but that again is no basis to exclude her testimony. Dr. Humphreys' retaliatory statements analysis is reliable without interviewers or consideration of positive statements. Defendants also argue that Dr. Humphreys' conclusion that the retaliatory statements damaged Miss Lively's reputation lacks support because she did not 1. Interview the creators or viewers of the captured posts. 2. Consider countervailing effects of positive statements near the retaliatory statements. Or 3. Speak with the parties in this case. Defendants offer no explanation for why these points render Dr. Humphreys' analysis unreliable, but instead summarily conclude that considering all these issues, Humphreys' analysis cannot plausibly support the conclusion that Friedman's retaliatory statements unequivocally caused harm to Lively's reputation. As explained, Dr. Humphreys' impressions model reflects a quantitative calculation of the impressions generated by the retaliatory statements. It does not depend on any individual user's opinion of the retaliatory statements. Dr. Humphreys' testimony on this point was unequivocal. What was relevant here was counting the impressions of the at-issue statements. Given this, defendants' complaint that Dr. Humphreys failed to consider the countervailing effects of positive statements near the retaliatory statements is irrelevant. Likewise, interviews with the post creators or the parties themselves would have no bearing on Dr. Humphreys' analysis because subjective beliefs are irrelevant to the dissemination of the retaliatory statements. Dr. Humphreys' impact assessment disposes of defendants' argument that Dr. Humphreys has failed to account for whether Miss Lively's reputation was in fact harmed by the retaliatory statements. Dr. Humphreys evaluated whether the 116 million impressions generated by the retaliatory statements harmed Miss Lively's reputation by looking at audience receptivity and the prevalence of the messages. She concluded that Miss Lively's reputation has been harmed by the retaliatory statements. Okay. This conclusion confirms the evident harm to Miss Lively without the need for individualized interviews. Dr. Humphreys' testimony regarding the damages model is the product of reliable principles and methods. Defendants take issue with Dr. Humphreys' damages calculation. They point to no errors in Dr. Humphreys' mathematics or CPM calculations to suggest her methodology is unreliable. Instead, they assert that Miss Lively's own media and the ameliorative reputational effect of a litigation victory would suffice to repair Miss Lively's reputation. This conclusory claim, which is also the subject of defendant's proffered rebuttal expert testimony, is no basis to exclude the testimony. Defendant's premise is also unfounded. There is no reason to believe that news of such a victory in this case would reach the intended audience at all, or with the frequency necessary to restore Lively's reputation following defendant's retaliation campaign. I don't know, I disagree with that. I do, because you look at how quickly the CRD complaint and the New York Times article, the huge spikes that caused. People are now watching this case, so if she now wins it, then actually, yeah, I think that would undo a lot of the damage that, in my own opinion, I believe she caused herself. Nor is there any guarantee that a successful jury verdict would persuade those who credited the retaliatory statements, since increasing polarization in the American context, both politically and culturally, means that attitudes about many topics have become entrenched and harder to change. As to Miss Lively's own platforms, targeting the receptive audience means identifying the audience that follows the sources associated with Mr. Friedman and Mr. Baldoni and others. There is no basis to presume that the audience that follows Lively on social media are the target audience that were receptive to defendants' retaliatory statements, or that Miss Lively's own assurances would repair the harm. Miss Lively also does not have infinite resources. Really? Are we running out of money now after this ridiculous lawsuit? She has substantial resources. Let's, not sugarcoat this. I do feel, though, with this statement, Miss Lively also does not have infinite resources. Is what she's saying here is, well, I need to fix my reputation. I don't have the infinite resources to do it myself. So Steve Sauerwitz does, though. I think that's what I'm hearing here. Maybe the skepticism in me, but I feel like this is where we're landing, because she keeps banging on about Steve Sauerwitz being a billionaire. And I do feel that there is... I think she's trying to play up the possibility of billionaire bias to the jury, but also I think there's billionaire jealousy. from her and her husband. Miss Lively does not have infinite resources to perform reputational repair activities, where allocating time and effort to reputational repair efforts comes at the opportunity cost of promoting her other brands, projects, and personnel brand. I thought you didn't have any jobs. I thought you said that you had no offers, and Wayfarer needed to pay you hundreds of millions of dollars because of that. Now she's saying, I'm not going to have time to fix my own reputation because I'm going to be busy promoting all these other brands and projects. Nor should Lively, as the injured party, be required to bear the burden. If she wins, yes, I do agree with that. Yeah, that's fair. Okay, so that's the end of that. The next expert would be Jeffrey Kinrick, who's, I think he's like the expert in the brands and everything. He can deal with the losses, the damages for her hair care brand and her beverage brand. Okay, I'm already seeing a line that I'm already annoyed about, so I feel like this is going to be a bumpy ride to get to. Because again, and I will point this out in the video when I do it, she was not, just, in a parallel situation where she was on the one hand promoting a movie and starring in a movie about domestic violence whilst promoting her brands. She crossed them both over and put, basically brought one in. She brought her brands into the movie, the promotion of the movie. And I don't love this attempt to try to separate the two, because it was the fact that they were crossed over that pissed a lot of people off. And she's just kind of trying to, pretend like, oh, no, that didn't happen. Let's look in another direction. She's trying to misdirect her, and I don't like it. Okay, so next video will be Jeffrey Kinrick.